to Module 5 of Week 1, Wills and Will Substitutes. And as we can see, the individual here is signing his will. And we'll know a lot more about wills after a few minutes of listening to this module. First of all, what is a will? It's a method of transferring assets by a decedent at death. That's by far the main use. Wills use the probate court to pay debts, pay taxes, and make requests to beneficiaries is another way of looking at it. And quite honestly, if a client asks me, well, why do I have a will? There's probably 10 good reasons, but I think these two are the major ones. And we're going to spend some time on it because will is probably, from Lee Shu's standpoint, the best way to transfer assets for the decedent. There's will substitutes, which to me are not as favorable for reasons of taxation. So if you have a subject to any kind of state or federal estate tax or inheritance tax, I think that it's a lot cleaner if you have the wills being used. Also, if you're subject to potential lawsuits or creditors coming after you, wills are much useful. But many people do recommend will substitutes for various reasons that are going to be self-evident. First of all, we have joint tenancy with rights of survivorship and tenancy by entirety. Both these type of real estate ownership are easy to transfer. Basically, it's going to be transferred by the deed being recorded with a death certificate in most states. Then we have trust, which I think more and more people are becoming familiar with in our society today and becoming more and more accepted as a method of holding property. Something called a TOD, transfer on death, which is for securities, and PODs, payment on death, which is for bank accounts that are, you list the beneficiary. Some states require you to have that on a bank account and on a brokerage account. Other states make it non-mandatory, although I do know some brokerage houses that require you to have a TOD, and it's quite honestly in the best interest because it's a will substitute. We can also have contracts, and we'll talk about the type of contracts that are considered as will substitutes because we give a unique definition of contracts for purposes of will substitutes. And finally, deeds. Let's get to the joint tenancy and tenants by entirety first. At death of the first party, assets are automatically transferred to the surviving parties. And this is typically referred to by operational law. So if you see the term operational law, they're probably, in most cases, talking about a joint tenancy transfer or transfer by tenancy by entirety. Again, the tenancy by entirety is straightforward. It's a spouse to the other spouse. And joint tenancy with rights of survivorship, in most cases, and preferred method is spouse to spouse, but there are situations where it's set up separately. For example, the brother and sister who at 18 and 19 buy property together in Hawaii and for some reason had a joint tenancy. And the problem of joint tenancy of non-husband and wife, the surviving beneficiaries are lost for the first to die. And that's the reason I don't like it, because what may be true today may not be true tomorrow. And so let's say there's two brothers and both of them are bachelors, they're in their 40s, and they decide that they should buy the property together because they can get have more power by joining their assets together. So they use joint tenancy with no intent to marry, just stay single. Well, 2 years after they buy the real estate, one of the brothers gets married. And guess what? 9 months later or so, they're about to have a child. That child doesn't get anything if he dies first. Transfers on death is a method of transferring securities to a named beneficiary at death, as I mentioned before. Many the brokerage houses require you to put a name on there, and again, it's in your best interest. I have really never seen a major problem on a TOD as far as complicating life and being outside of a will. In fact, I liked it from the standpoint is that it transferred immediately, which means we can just continue to make good decisions about what investments we're in. Where if it's in probate, it becomes very difficult over a 4 or 5 year period to get changes made that are necessary to maximize the benefit of the securities. Payment on death is used by bank account, named beneficiary of death, and again, it's very similar to the TOD in that it makes a lot of sense to have that automatic transfer. Again, a control of the assets, and then again, we have to realize that they are subject to debts, they are subject to creditors, and they are subject to taxes. But usually we can, with a little common sense, we control the assets until we make sure that passes, which we'll talk about later. Contracts is a very narrow reading of the term as used in estate planning as a will substitute. They're limited to, first of all, life insurance contracts on the life of the decedent that are owned by the decedent. Second, retirement pension plans owned by the decedent. Third, business contracts, which might include business options or buy-sell agreements, and then prenuptial agreements. Now, giving tests, there'll be the question of which of the following is not a will substitute, or a contract will substitute, is probably what I'll say, and we'll put in something. And one of the students will say, well, that's a contract. Well, it is a contract, but for purposes of estate planning and being used as will substitute, contracts are limited to the life insurance listed here, retirement, business contracts, and prenuptials. That's it. And again, these are nice in that they are will substitutes, and they override a will. And that's what people forget sometimes too, is that when we have a will substitute, it overrides a will. Deeds. Deed can be a will substitute in some states. It does require an escrow, and many times that escrow is an attorney. So you have to check with your state law, which is again having your client talk to an attorney about whether or not escrow is a good way to have a transfer as a will substitute. I've known it being used several cases back in the Midwest. Again, it's going to be more out of a state decision on how it's done. Will substitutes are not perfect. Will substitutes ignore outstanding debts and taxes to the deceased. I might note that related to that, sometimes when you publish the fact that someone died, which is you're required to do for purposes of a probate court, to general creditors, there are people who will submit a bill and that was not real. They just sent it to all of the people who died, the obituaries, seeing if they get some money out of it for $800 or $900 or maybe even more. So do not be surprised if you see bills coming out of the woodwork that are not real. In some cases, the executor or administrator will go very thoroughly through and verify each of the debts. In other cases, they don't. They just pay them because the volume is so big. And you look at value added by how much time it takes to check something out for the small amount of money being requested. But it is a problem, quite honestly, since we are required to have the publication of death, that people do try to sneak in bills that aren't real that make a little bit of money off the deceased. Now, let's face it, if you have $100 and you get 1,000 people to do it, that's $100,000. I'm sorry, $1 million. I'm not as good as math. Statute of limitations may run years after death, and that is true, for example, in the contract areas. Each state is different as far as statute of limitations, so each state's different as far as how long after death you have to be concerned that someone can come back and get money from you that you received as the bequest. And then finally, there's no legal protection under will substitutes that you have under wills. That is where we're going to, as far as we're going to go on wills in this session. So we will continue the next module in just a few minutes if you're available. Otherwise, again, you can look at it at